Webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the incredible Rebecca Hicks, a Texas construction lien law expert. Today's webinar topic is payment bond claims on private and state government projects, the basics. So without further ado, I'd like to introduce the fabulous Rebecca Hicks.
Hello, everybody. So thanks for being here this morning. We're going to talk about a subject that's near and dear to my heart, payment bond claims. And you probably know this, but Texas mechanics lien and payment bond law is some of the most complex in the country. So are you going to leave this seminar being 100% expert on this subject matter? No, we'd be here all day or longer. But what I hope you can leave here with is knowing what your deadline is and being darn sure which projects are bonded, should be bonded or not, so that you can at least take those first steps to protect your right to payment. All we're talking about today is protecting your right to payment for the work that you do, material you supply, that sort of thing. That's the whole goal of the law about payment bonds. So let's jump in. If you have questions, I would prefer to answer your questions during the seminar. So if you want to put your questions in the chat box, that's great, because then Jessie will let me know. She'll tell me that there's a question and we can discuss whatever your question is. If you have a question, somebody else that's listening very well may have the same question, so go for it. So now payment bond claims, the basics. Here are the key questions we have to know so that we can determine whether a project that you're supplying material to or you're doing work on is bonded or not. We've got to know where the project is, right? That's step number one. Who's the owner? That's the key to whether it's bonded or not in most cases. What's your position in that construction chain? And then finally, you got to know, is there a payment bond? So who's the owner? There's really four categories of ownership that a project can be classified under. And you're not going to know which type of rights you have, what your deadlines are, or what you need to do unless you know who owns the job. It can be a private project. So that means anything, it can be a state or local government project, federal project, or finally a public-private partnership. So let's talk a little bit about what I mean by those. Private project, what do I mean by that? Anything that's owned by either a private entity, that means a corporation, a limited liability company, an Inc., or owned by individuals. That means it's privately owned. So it's not owned by a governmental entity. That's what we're talking about. So the law that applies to private projects is Chapter 53 of the Texas Property Code, and that's most of the time for a private project, it's going to be a mechanics lien claim, not a bond claim. So that's the important thing to remember. When you know a project is private, it's a private project, it's generally going to be a mechanics lien claim, not a bond claim. So that's not going to be a huge focus of what we're talking about today. State or local government projects, what does that mean? Anything that's owned by any of the subdivisions of the state of Texas. If it is a school district, let's say you're doing work for Harris County ISD, Dallas ISD, any school district that has an ISD after it, that's a local government project. You're doing street improvements or infrastructure work for any sort of mud district, or you're doing that type of work, street work for TxDOT. Those types of work. That's what we're talking about, state or local government projects. Anything like that. State or local government projects are governed by Texas Government Code Chapter 2253, and these jobs will be bonded. There will be a payment bond posted to protect subcontractors and suppliers. So that's what when you're dealing with any sort of state or local government job, you know it's going to be a bond claim. You're not going to be filing a mechanics lien claim. You're going to be making a bond claim. And we're going to talk about what that means a little more in a few minutes. Then the other type of project that you may be working on, because our federal government does a lot of construction work, right? You may be working on a federal government project. What does that mean? If you're doing construction on a military base of any kind, you're working on post offices, you're trying to build a wall that President Trump wants to build, those would all be federal government projects. Federal government projects are also going to be bonded. There's going to be a payment bond. So that's governed by the Miller Act, which is in 40 U.S.C. 3131. Separate rules, but a bonded job, none the same. So there will be a payment bond claim. The other type of project that's getting more popular all across the country is public-private partnerships, P3s, right? And these are those projects that are basically it's a government working with a private company dually. And so those types of projects, there's no clear answer to is it public or is it private. We don't have to care in Texas because our legislature said, you know what, we're just going to avoid this confusion. If it's a public-private partnership doing a project, we're going to require a payment bond. So anything that is a public-private partnership that you may be working on is also going to be bonded. You're seeing this a lot of times for example, here in Dallas, we'll see public-private partnerships for building toll roads, some of the road work for these toll roads and more. Or we had a public-private partnership to build the Omni Hotel in Dallas. The Clyde Warren Park was a public-private. Some of those big infrastructure things like that are getting done via public-private partnership. Those will be bonded. So it will be a bond claim. So the first thing you've got to know, well, is there a payment bond? What the bond, and when we're talking about payment bonds for right now, what we're talking about is the bond that's posted by the general contractor on the job. So that means the contractor, when I say general contractor, it's the contractor that has their contract directly with the owner for the job. So they've been hired by an owner to build something, general contractor, and they have posted a bond, a payment bond. You also could have a subcontractor bond, and we'll talk a little bit more about what that is in a moment. Government jobs, anything state, local, or federal, there will be a payment bond. So if you're working on any of those types of jobs, there's not a question, there should be a payment bond, and you need to get a copy of it. Private jobs can be bonded. So those jobs that are owned by private entities or individuals, Chapter 53 of the Texas Property Code says any of those jobs can be bonded, but they don't have to be bonded. The majority of privately owned jobs are not bonded. The larger the job gets, the more likely it is to be bonded. So example, if it's maybe a private hospital being built and it's a very large project, that would be much more likely to be bonded. It's just in the contracting process, the owner and the general contractor negotiate that that general contractor will provide a payment bond, and they do it just as part of the contracting process if that's what they choose to do. There's nothing in Texas law that requires a private job to be bonded. Some are, and if you don't ask the question, you're not going to know that. So you have to ask the question. So now let's take a step back and make sure we all are on the same page. What in the heck is a payment bond? Rebecca's talking a lot about payment bonds. What is that? A payment bond is, generally speaking, an insurance policy that's purchased by, in most instances, the general contractor, that they go out to the surety, which is just an insurance company. A surety is an insurance company, and they purchase this insurance policy called a payment bond that basically says, hey, Mr. Owner, I'm contracted with you to build this project. I'm going to employ subcontractors and suppliers down the road, down the chain of construction to get your job done. If I do not pay those folks for any reason, here is this insurance policy that will pay them on my behalf. That is what a payment bond is. It's an insurance policy that's posted by a general contractor to ensure payment of subcontractors or suppliers further down in the construction chain in case that GC defaults on payment. That's what it is. So let's talk about gotcha, what I call gotcha types of bonds, because it can be confusing. It's a confusing world out there when you start asking for payment bonds. When a general contractor has to bond a job, they generally have to post two different types of bonds. They'll have to post what's called a performance bond and then the payment bond we just talked about. Well, the confusing part about that is when you ask for a copy of the bond, most of the time they will send you both at the same time, often in the same PDF file. Because most of the time, you know, this day and age, we're getting these by email from general contractors or owners. They're just sending us the bond by email. And you'll get this one PDF file that has both a performance bond and a payment bond. So what's a performance bond? The performance bond is a separate type of insurance policy that the general contractor purchases. And that insurance policy says, hey, Mr. Owner, I'm contracted as general contractor to build your hospital. If for any reason I'm not able to complete your hospital, then here's an insurance policy where the surety is going to step in and complete your project for you. They're going to hire a replacement contractor and get your hospital built if I can't. So that insurance policy is not going to benefit subcontractors and suppliers. It is meant only for the benefit of the owner. So in short, you don't care about the performance bond for what we're talking about today. You care about the payment bond. And the reason I'm saying this to you is they often send them at the same time. And sometimes they have different bond numbers. Sometimes they have even different sureties. If you try to make a claim and you send it based on information you've just gotten from a performance bond rather than the payment bond, your claim won't be good. So you have to make, and so what you'll need to do is look at the bonds closely when you receive them to make sure it says at the top. They'll all say at the top which one they are. I've never seen a form of bond that doesn't say what it is at the top. They'll generally be labeled payment bond or performance bond. You care about the payment bond, not the performance bond. That's why I'm bringing this to your attention. Don't get confused by that. So the payment bonds that we're talking about, we've been talking about, is the bond posted by the general contractor. And that's the one, you know, that basically says, hey, Mr. Owner, if I don't pay my subs and suppliers down the chain, this insurance company, this surety over here is going to pay them on my behalf. Great. Well, more and more companies, more and more general contractors are pushing that risk down, usually to the first tier, bigger subcontractors. And they're saying, hey, well, I'm having to bond this job, Mr. Electrician. You're going to need to get a payment bond as well for my benefit. So they're pushing the risk down to usually that first tier subcontractor level, requiring those bigger subcontractors to go out to their surety and buy an insurance policy that says, hey, Mr. General Contractor, I, as a first tier sub, am going to have to hire second and third tier subs or suppliers. If I don't pay those, then here's my bond that will pay them on my behalf. But what you need to know is subcontractor bonds are the wild, wild west. There is no statute anywhere in Texas law that governs subcontractor bonds. It's just a pure product of contract, whether the general contractor requires it or not, and whether they contract that into the subcontract or not. And so there's no rules, and you have to just do what the bond says. When you see a subcontractor bond, how are you going to tell a subcontractor bond, payment bond, from the general contractor payment bond? You're going to have to know who the parties are in the construction chain, from owner to general contractor to first tier sub, all the way until you get to you. And you're going to have to look who's the principal on the bond. If the principal on the bond is a subcontractor, that should twig, hey, this is a subcontractor bond. There's probably still a general contractor bond. I need both, because you want to make a claim on both the subcontractor bond and the general contractor bond. Great. So practical advice. How are you going to get these? Because you can't make a bond claim if you don't have the bond information. The key thing to do, the best source, obviously, of getting the bond information is getting a copy of the payment bond. A payment bond is generally a 1 to 2 page document that, in legal terms, basically says, will identify the general contractor, will identify the owner, will identify who's the principal on the bond and who's the obligee, and then it will say what it's protecting. It'll identify the project. It's a very legalistic looking document, but it's usually only one page. It'll say payment bond at the top. If you read it, it'll identify the surety, the general contractor, the project. Right. How are you going to get your hands on a copy of that bond so that you can make a claim? Ideally, you want to do this up front before you ever have any payment issues. Let's say right after you sign your subcontract, you're gathering project information. Part of that, you're getting a copy of the payment bond. Most of the time in our office, if we get a claim referred to us and we don't have the bond, the client doesn't have the bond, we're calling the general contractor and just asking them, hey, can you send me a copy of the bond? And then generally you follow it up with an email. Most of the time, within a day, they email us a copy of the payment bond. Why? This shouldn't be any controversial thing. Any sort of general contractor of any size or sophistication understands that the payment bond is an insurance policy that is there for the benefit of subcontractors and suppliers. They're supposed to give you a copy if you ask for it. So it shouldn't be any weirdness just asking for it and them supplying it to us. Of all the claims that we deal with on a monthly basis, we generally have no problem at all getting copies of these payment bonds just by asking the general contractor. So that's the first way you try and get it. Sometimes they may refer you to their surety or their bonding agent. Some folks just want their agents dealing with sending out copies of their bonds. If that's who they refer you to, we'll just make the request of the surety or their bonding agent, and they'll send it to us. Now, sometimes with some of these surety agents, they'll verify the bond information. They'll tell you the bond number, the surety, that type of thing, but they'll say, oh, I can't give you a copy of the bond. If that happens to you, you just kind of have to go back to the general contractor and say, hey, can you give me a copy of this bond? Here's my concern if someone just tries to provide you bonding information. They just provide you a bond number and the name of a surety without actually sending you a copy of the actual bond. It has happened more than once in my career, 25-year career, that somebody made a mistake. They told you the wrong bond number. They just got one of the digits wrong, right? They either typed it wrong on their little document or they told you wrong on the phone. Or these sureties. Sureties have very similar names. Like Travelers has, I forget how many subsidiaries. And so if you get that name wrong or that bond number one digit wrong, is your bond claim good? Maybe not. We don't know. We might have to go litigate it. Nobody wants to litigate that. You want to get it exactly right. The way to do that is to get an actual copy of the bond. If all you can get is bond information that somebody's just told you or provided you, you have to go with it, right? But ideally, you want to get a copy of the actual bond. Sometimes if a private project is bonded, remember, private projects do not have to be bonded. It's purely whether the owner and GC have decided that there is going to be a bond and contracted for such. So if the private job is bonded, those payment bonds are supposed to be recorded in the real property records in Texas. Does that happen all the time? No. Is that a good place to look and see if you can just find a copy of a payment bond? Sure. Just look online at the real property records for whichever county your project is in, and you may be able to find the payment bond there. Government jobs, you will not be able to find the payment bond in the real property records. It's not going to be recorded on a government job, but on a private job, it may. Also, practical advice on how to get these payment bonds. One way, if you get pushed back or you're not getting what you need on a public project, meaning a state or local government project or federal government project, you can usually just make a FOIA request, Freedom of Information Act request, asking for the bond. Now, here's the caveat with that. It's not going to be a real fast turnaround. We know that government entities don't move fast. And right now the federal government's closed down. So, but if you have to make the request well in advance of what your deadline would be to make a bond claim, or you're not going to get the bond in time. So you have to make that FOIA request early. And it's real easy to do. There's normally just a form, easy to do form that you fill out online to make the FOIA request. You submit it, and you'll get the bond maybe a week or two later. It's normally how it'll happen. Now, step number 2. What's your deadline? If you don't learn anything else from this seminar, this would be the part I would really remember, pay attention to, is what's my deadline to make one of these bond claims. Here is for a private project. When do you have to make the claim, the bond claim? 15th day of the 3rd month. is when that letter goes out. So, and what this is, if you are already doing lien notices on private projects, then this is going to be, you're already going to know this deadline, because for a private project, the deadline is the same for a bond claim. If a private project is bonded, it's that 15th day of the third month deadline. So January, if you did your work and provided your product in January, then you've got to get the fund trapping notice letter out, the third month notice letter out by April 15th. And that same letter is going to be your bond claim. The only difference is you add the surety to it. You add the surety's address, both that they have on file with the Texas Department of Insurance, which is public information. You just look it up online. And then you also make sure that you include the claims address in the actual payment bond. There's generally a claim address for the surety in the bond itself. Both of those addresses would be just added to your normal third month notice letter. That is your bond claim. You just made your bond claim if you do that on a private project. So 15th day of the third month, that's your deadline. So for these private projects, the steps to perfect that bond claim, seriously, are just sending this very same notice that you would send on a private project, that 15th day of the third month notice letter. In Texas, we have a statutory form we're supposed to be using at this point, and SunRay, I think, is helping you guys, maybe helping you guys with some of these notice letters. So to make a claim on that payment bond, they're just sending that same form of notice, that statutory form of notice, adding those addresses for the surety, the one from the Texas Department of Insurance and whatever's on the bond itself. And then you've just made your bond claim. For a private project, if there is a payment bond on it, technically speaking, you do not have to take the next step and file your mechanics lien. You don't have to. The law says you don't. As a practical matter, my office, we generally file a mechanics lien anyways. Why? It just adds a different level of pressure to the owner to get the job paid. There's nothing wrong with you filing a mechanics lien on a bonded job. You can go ahead and file your mechanics lien in addition to sending that third month notice to the surety. When you send notice of your filed mechanics lien, you would send that to the surety as well. So that's kind of how it would work. You go ahead and file that mechanics. My advice is to go ahead and file that mechanics lien, even though you don't technically have to. So who gets all these notices? All these notices we're talking about, who gets them? For this private project, you're obviously going to send it to the owner, but we usually send it to the owner at their principal place of business and their registered agent from the Texas Secretary of State. If there's a separate address on the deed, we'll send it to that as well. General contractor, same thing. You're looking up their entity on the Texas Secretary of State. You're sending to their principal place of business and their registered agent address. Why do I include the registered agent address? Texas law requires every company, anything that's an LLC and Inc., anything like that has a corporate form, they've got to tell the Texas government, well, who do I want to receive legal notices on behalf of my company? They have to provide a real name for a real person to receive their legal notices, and that is called their registered agent. And so that registered agent is designated with the Texas Secretary of State by these companies, because these companies are saying, this is the person that should get notice for me. So you want to get it to that person, right? First tier subcontractor, if you're not the first tier, you want your notice letter going to that first tier sub as well. And then for these jobs that are bonded, you're sending it to the surety at that registered agent address from the Texas Department of Insurance, and also the address on the bond. On a subcontractor bond, remember we've talked about that situation where the GC is pushing that risk down and has required maybe those first tier subs to also put up a payment bond. There's no rules. So you just got to read the bond and do what it says. Practically speaking, most sureties are using the same form that they're using for a general contractor bond for the subcontractor bond. What does that mean? That means if you use the statutory form notice for a private job and you are mailing that to the surety, it should also comply with the subcontractor bond on a private project. So there, if you've got a job where it's general contractor bond and subcontractor bond, then you would want to just add all of the sureties to your letter you're already going to send out anyways. So you'd put the surety for the subcontractor bond information right on there with the surety for the general contractor bond and just mail it to everyone. This is how you would probably proceed. the best way that's how we handle it in our office. So now let's switch gears. All of that was about private projects. Let's switch gears and talk about if you're working on state or local government jobs. This is those school districts, those tech stock jobs, all of that stuff. Right. Then our bond claim deadline for these is there's 2 deadlines you're going to have to meet for a state or local government bond claim in Texas. And one of them comes really friggin' fast. For these state or local government jobs, there's still a 2nd-month notice required. 2 legislative sessions ago, we got rid of the 2nd-month notice, the preliminary notice for private projects, jumped straight to the 3rd month. Great, that's beautiful for private projects. Didn't change for public projects, did not change for state or local government jobs. You still have to get that 2nd-month notice out. So for January, February, March 15th, that's notice got to go out, right? So here we are in October, November, December 15th, that 2nd-month notice has got to go out. It's got to go to that general contractor on the job. That 2nd month comes fast, so get that out. And then the next step, there's a 2-step process. The next thing you've got to do is get your actual bond claim out by the 15th day of the 3rd month. So second month preliminary notice, following month you're going to have to send out your actual bond claim. And we'll talk a little bit about what those need to look like momentarily. So, here's your steps to perfecting a local government claim, state or local government claim, that 2nd-month preliminary notice. And that 2nd-month preliminary notice only applies if you aren't contracted directly with the GC. So if you're a 1st-tier sub, you don't have to send a preliminary notice. Why? Because the purpose of that 2nd-month notice is to give the general contractor notice that you haven't been paid. If you're contracted directly with the general contractor, they obviously already know you haven't been paid. So that applies only for those that do not have a direct relationship with the general contractor. 3rd month notice, everybody's got to send it, right? So, and it must include a sworn statement of account. This isn't just a letter that goes out. It's a letter plus a sworn statement of account that has to go out. And we're going to talk about what that needs to look like. So when we're talking about this preliminary notice, that's going to be coming from that 2nd-tier subcontractor or supplier, anybody that doesn't have a relationship with the general contractor. And it's a pretty simple form of notice that just goes to that general contractor and says, hey, I'm out here, I contracted with your 1st-tier sub and I haven't been paid. So here's just an example of what we use for a preliminary notice letter. And the statute is real loosey-goosey on what this has to be, but really the statute, all that the statute requires is that you get that general contractor notice by the 15th day of the 2nd month that you're working on a job and you have not been paid. You can just if you just wanted to certified mail a copy of your invoice, that probably would be sufficient under Texas law. This one, I'm a lawyer. What are we going to do? We're going to send a really legalistic looking letter that kind of cites the statutes, and that's what this is. You'll also notice as part of this letter, we're asking for certain information because that preliminary notice, that's a good time that you can go ahead and, if you do not have project information like copies of the payment bond, etc., you can go ahead and ask for it because then you would have the information when you need it the following month to make your bond claim, right? Right. So that's why you see that there. So what's your next step? You've sent that preliminary notice the 15th day of the 2nd month. Now it's time to make your bond claim, 15th day of the 3rd month. The statute here has very specific language that you've got to have a sworn statement of account. Here's what I call the magic language that's directly from the statute. Anytime you see a sworn statement of account for a bond claim, it needs to include this language that all just and lawful offsets, payments, and credits known to the client have been allowed. It's got to be a sworn, and when I say sworn statement, it is the equivalent of an affidavit. That means it's a written statement that you will swear to in front of a notary. You are swearing to the veracity of what that statement says, and so it can be evidentiary to this surety. That means when you get one of these, if you've got third parties working on them for you and they send it to you, you need to review it carefully because it's not just a technicality that you need, oh, I need to get this signed and here's the notary. you are swearing to the veracity. You're swearing that everything in that statement is true and correct. So review it carefully if you've got somebody else drafting this or working on it for you. So for these bond claims for Texas state or local government jobs, there's several different levels of what the bond claim needs to include, the information the bond claim needs to include. There's part of the statute that deals with if you do not have a written contract. And then there's part of the statute that deals with if you have a written contract. And then there's part of the statute that deals with whether you have a unit price contract. And so with my office, to avoid that complexity, we just make sure every single bond claim we do kind of complies with all of the basics, just so we're not worrying about these technicalities. But it's just basic information these claims need to include: the name of the party who you contracted with, the approximate dates of performance and delivery, a description of the public work, labor, or material. And here, when you describe what you're doing, if you're the electrician on the job, you would just basically describe electrical work. One way to just avoid kind of that confusion is look at the scope of work as it's described in your subcontract, and that's your description of work you're going to include in your bond claim, right? Or if you're selling material, just let's say you're renting equipment, you'll say rental equipment. That's a general description. You obviously have to include the amount due. So where does this 15th, our notice letter that we're talking about, our bond claim letter that's going to also include this sworn statement of account, if let's say you're this first tier subcontractor, that's going to go to the general contractor and the surety. That's who it's going to. And those addresses we talked about before, same addresses, right? General contractors getting it at their principal place of business, their registered agent address. If you've got an email, include that as well. The surety's getting it at their TDI registered agent address, Texas Department of Insurance registered agent address, and the notice address on the bond. That's who's getting that notice letter. Here's just an example of what we usually do as far as a bond claim. This is what a form that our office uses. And SunRay, obviously, if they're doing this stuff for you, they're going to be using some similar type of form. And then this is when I'm talking about a sworn statement. This is the part that is going to be sworn by you. You're swearing that it's true, has to be signed in front of a notary. So you'll see that it would include basic project information, ticking all those boxes that Texas law requires, and then getting it sworn in front of the notary. This is the substance, this is the there for your bond claim. If you just send a letter without this sworn statement for a bond claim for a state or local government job, it's not a good bond claim, will not be enforceable. So that's the big takeaway here. If you are doing work on a unit price basis, so if you're providing something by the linear foot or the square ton or whatever, those types of things, or if you're doing, if anything that is you're renting by the hour, those types of things, you want to also include the information required for a unit price contract by Texas government code. So that would mean the law says it needs a list of units or the unit prices. How are you going to usually do that? You'd be able to, most of the time, your invoices are going to include the number of units and units sold. So you can comply with that by including copies of your invoices most of the time. It might take you including a copy of your purchase order if that's where the unit pricing is delineated for your particular job. And then you want to be able to have a statement as far as how many of the units contracted for have been completed and how many are still left to complete, or partially, how much is completed and how much is partially complete based on what you contracted to do. That's what the statute requires on those unit price type of agreements. So now let's talk about limitations. Any sort of lawsuit on a payment bond claim needs to be brought by the first anniversary of the date you first sent a notice on the payment bond claim. So you cannot just let these make the claim and just kind of let it sit out there. And we all think as we sit here today, well, I'd never let a year pass. Well, this is the realistic scenario. You start negotiating with the general contractor. They're like, oh, we're in arbitration with the owner, so when that's done, we'll get you paid. I know you've got the bond claim, but just give us some more time. And you wait and you try to be a good faith partner, and then you somehow a year goes by much faster than you think it's going to. Anytime you send a bond claim and it's getting even close to a year, let's say 9 months in, and the surety has not paid the claim, and the general contractor has not paid the claim, you have not been paid, you have to get your lawsuit on file. If you let that year pass, it's no longer, you've just lost your claim just by sheer missing the statute of limitations. And for these bond claims for state and local government jobs, that bond claim that has to go out on the 15th day of the 3rd month has to go out after each month that you supply labor or materials to a job. So that means if you supply labor or materials to a job for several months and you haven't been paid for several months, you may have to send several different bond claim notices. That 1 year limitations deadline is going to run from the first letter you sent, not the last one, right? So be very conservative. Don't even get close to that 1 year limitations deadline. So now let's talk just real briefly about federal projects, Miller Act claims. These are the easiest to perfect. So if you are doing work on federal government jobs, there's just one deadline. And that is the notice has to go out 90 days after you last furnished labor or material to the job. So it's a pretty lenient deadline, runs only from the end of when you did your work, and you've got to get that one notice out by the 90th day after your last furnishing. And that's it. So that 90 days date of the last labor or material, you all want to make sure that you work that from the last day you substantively provided work to the job, not punch list work. So don't wait for that punch list. So when you sent your last pay application, that's where that 90-day deadline is going to start running, not when you were back out there doing punch list work or something like that. The last substantive work that you bill for on that job, not billing for retainage. Okay, that's what we're talking about. So if you're a first tier on a federal job, technically speaking, you've contracted directly with the GC. Technically speaking, you don't have to send a notice at all. You just magically have a bond claim. That's the way federal law works. But now, practically speaking, if you don't send a notice to the surety, how do they know you're asserting a claim? How do they know you haven't been paid? So send the claim anyways by the 90th day, but technically speaking, you don't have to. Second tier, you've got to send that 90th day notice. So the weird part, and sometimes the gotcha part about federal projects is that federal payment bond law only protects the second tier subcontractors. It does not protect the third tier. So if you happen to be third tier, then what you need to do is make darn sure that whoever you contracted with at the second tier gets their bond claim made and includes the amount that's owed to you in the bond claim. Because you as a third tier are not covered. That's just how federal law works. Do I think it's fair? No, but that is the current state of federal law on these bond claims. So, subcontractor versus supplier. Yeah, there's this weird difference in federal law as to what they're calling a supplier versus a subcontractor, and they really try to parse the federal statute, the Miller Act, and say, well, subcontractors are protected to the second tier, but suppliers aren't. And the way they try to parse that is if all you do is deliver material to a job site, you don't do any installation or anything like that, then maybe you're not protected even to the second tier. You're only protected at that first tier level. But you know, it's just one of those. That's a battle that you would have to fight if you end up being a second tier supplier only. And so the functional thing there is, did you actually do any labor, or did you perform anything on the job other than just dropping off material? That's kind of the bright line. So on these federal jobs, you've just got to get that claim out there within 90 days. And this language I've got here on this second bullet point in the slide, that's just the language directly from the statute. It is kind of a very kind of loosey-goosey. You've just got to tell them the name of the parties, how much is owed, the very, very basics. So for federal, these Miller Act claims, for all of the notices we've talked about for private projects and state and local government jobs, those notices have to go certified mail return receipt requested. They do. Email doesn't work. Regular mail doesn't work. Certified mail receipt requested is how it has to go. And that's gonna that type of delivery is also going to be fine for these federal Miller Act claims. But they also say that you can use UPS or third-party delivery services, and these state court notices, state notices, you can too. State or local government, private project, you can use those too if you want to. If you want to use FedEx, you can. If you want to use UPS receipt of delivery service, you can. Well, I'm saying certified mail return receipt request is the way to go because it's just a lot cheaper normally. If you had a super big claim and you thought FedEx might be better just because of the reliability, go for it. But otherwise, certified mail return receipt requested is generally how you want to send these notices. And here's just an example of what one of these federal bond claims would look like. Notice here, you do not have, for these federal bond claims, there's no requirement that it have that sworn statement of account that we talked about that's so important for state or local government jobs for that bond claim. You don't have to have that. It's just a simple notice letter with some basic project information. Let them know that you haven't been paid and how much you haven't been paid. So that's kind of how federal claims work. Same thing for timing of suit. You've got to get that it's a 1 year. So it's going to be 1 year, but this one runs from the last day you supplied the material. So it can be backed up even a little bit more for that 1 year when that 1 year started for a federal bond claim. Remember, we talked about the 1 year for a bond claim you've done on a private project or a state or local government job, and that's going to be that 1 year from the day you sent the claim, you mailed the claim. Here, you got to back it up even before because it's going to run 1 year from the last day you were doing your work on the job. And you remember your notice didn't have to go out until 90 days after that date. So you've got to just make sure that you're running your 1 year for those from the date you last did work on the job, and then getting that lawsuit on file within that 1 year. So okay, we've been talking a lot about making these bond claims and when you got to do it and what that notice needs to look like. Well, okay, so you've made your bond claim. What do you got to do next? Normally, the way this works out is you send a bond claim. I'd say usually within 2 weeks of you having mailed out that bond claim, you're sending it to that surety, right? Somebody from the surety, a representative from the surety, is going to send you a letter. They're going to send you a letter that acknowledges the claim. And a lot of times they send you, in this letter, they'll be requesting additional information. So sometimes they have a claim notice form they want you to fill out, and they'll ask for copies of invoices, copies of delivery tickets, copies of your contract, basic project information and documentation. You need to play ball with the surety on that. So you need to, when you receive one of those letters asking for that information, you want to send them back a letter and give them all the information that they've asked for to the extent you have it. If you don't have that information, you just let them know, hey, we don't do it that way. We don't have that. If they want you, even though you've already sent a full-fledged bond claim with a sworn statement of account, if they want you to fill out their claim notice, and it's another sworn document, fill it out and send it back. So that's how the first rattle out of the bag, that's usually how it works. Once you have provided the additional information that surety asked for, then, here's kind of one example. But once you've provided that information that the surety asks for, then the next step is you should you'll be in a process of negotiating with the surety after that. If your claim is fully timely, you sent out all your notices on time, it went to all the right parties, it meets all those statutory requirements, they'll usually pay the claim, step up and pay the claim. Here's the caveat. If the principal on the bond, the GC who posted the bond, disputes the claim for any reason, don't think the surety is actually going to just step up and pay that. They are going to let their GC fight the battle, let their principal fight that battle, bring on, and so then at that point you're still going to be in the process of having to prove that whatever the dispute is doesn't have teeth and to litigate your claim. It's not a get out of jail free card just because you have a bond claim. If there is a good faith dispute about either the labor or materials provided, let's say they say your work didn't meet the project requirements, or the material you provided didn't meet the specification, the surety is going to rely on what their GC says about that, what their principal says about that. And so they're not just going to pay the claim over a dispute. They're going to let that dispute play out. So that's really all my planned comments today. I'll be happy to answer any questions.
Well, Rebecca, I mean, really, you are incredible as always. You pack so much information for us, so I really do appreciate it. There are a couple of questions that just came in. The first one, it says, I received a letter, and this is actually kind of tying into, getting communication back from the surety or the bond company. It says, I received a letter from the surety company stating that the third month bond notice that I sent is just a notice and not the actual bond claim. On a private job, if I send my third month bond notice timely and the bond company and appropriate entities are included and noticed, is that my bond claim, or do I need to send an additional document?
Know the letter you're talking about. I know this letter. It is the most asinine letter. And there's a lot of sureties that are sending this right now. It seriously is a letter that, hey, we got your letter. It sure sounds like a claim, but we think you're just sending notice. That's not a claim. You know what we do? We send back I think it's probably like a 3-sentence letter that says, hey, yeah, we're making a claim, thanks. Yeah. So that is how we respond to that letter. Yes,
okay,
this
right.
is a claim.
Okay, thank you so much.
What they will do next is when you send back the letter that says, yeah, I actually meant that, then they will send you the next letter that says, give me all this other information. And then you'll have to provide them all the other information.
All right, perfect. Thank you so much for that clarification. Okay, and then another question came through, and I think you actually already answered this as well. It says, on a private bonded job, would I send the third month fund trapping notice as well as a third month bond notice, or if the bond company is listed on my fund trapping notice, does that properly notify the bond company for the bond claim as well?
Yes, if you just include the sureties on the regular old fund trapping notice letter, statutory form, third month notice, that is your bond claim on a private project. Here's my only big caveat. If you are doing residential work, meaning you're working on large residential developments, there is a gray area in Texas law as to whether sometimes those jobs are partially mud district. But if you look at the deed, it's still, that property's all still privately owned by the developer. So there's a gray area as to whether those are going to be considered 2253 local government jobs because of the mud involvement, or private project jobs. If you find yourself in that gray area, that's the only situation where I would do both. That I would send the bond claim notice with the sworn statement, as well as the fund trapping notice letter, and because you want to perfect it as both public and private, just because we've got a gray area in Texas law right now.
Okay, wonderful. Well, thank you so much for clarifying that. If anyone does think of any other questions that weren't addressed, please feel free to reach out. We'll be sure to answer any questions for you. One other thing I wanted to mention, if you guys are in the Dallas area, Rebecca is going to be presenting alongside with Ariella for a live seminar next Friday, November 7th, for how to get paid faster with liens, bonds, and contracts. So if you're interested, please, 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 we'd love to see you guys there. You can register at sunraynotice.com/seminar. Again, that's sunraynotice.com/seminars. We'd love to see you guys there. All right, can you go to the next slide for us, please? All right, here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. There's a lot of really good information on there for you guys to help you guys know what you've got going on those projects and make sure that you've got all the resources and information that you need. All right, and then the next slide, please. All right, if you don't mind, take a quick moment to give us a review on Google. We'd really appreciate it. It takes about a minute of your time, but it helps us get information and feedback from you guys and help to improve our webinars and get the content and topics out there that you guys are looking for. And then the next slide. And with that, that is all we have for you guys today. Thank you so much to everybody who attended. Again, Rebecca, you really are incredible. So thank you so much.
Thanks,
I hope
guys.
to see you guys at our seminar next week. Have a wonderful day. Thanks again, guys.